Let's go on the record in docket 22-00846. That's people of the state of Michigan versus Tyron M. Anderson. Will the parties please introduce themselves for the record?
Yes, good morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Good afternoon, Your Honor. Kimberly Stott on behalf of Mr. Anderson, who's standing to my right.
And you are Tyron M. Anderson?
Yes.
Okay. This is the time set for preliminary examination of 1:30. Mr. Pfeiffer, how are we proceeding?
Your Honor, the people are requesting an adjournment today due to the fact that I discovered about 90 seconds ago that the primary testifying officer for the case, Officer Ariana Clark, is no longer an officer with the Lansing Police Department. And therefore, she would not have gotten our subpoena that would have been sent out to the Lansing Police Department station, where we send all Lansing Police Department subpoenas. And therefore, I'm requesting a subpoena today. There's already been a waiver of the 21-day rule, and there have been 2 previous adjournments by defense solely for defense requests. And so I am asking for a brief adjournment in order to be able to get the subpoena actually to Ariana Clark.
Response, Ms. Stout.
Yes, Your Honor. I object and ask for dismissal. The reason that defense had asked for an adjournment was because I had not received all the evidence. It was on evidence.com, something I wasn't familiar with, and also wasn't showing up on my email. Finally, I spoke with the gentleman, a very kind gentleman named Dominic, and was able to access everything. I know there's several police officers that could have been available. I'm sure if they subpoenaed Lansing Police Department and it came to Clark, they would have said, they should have said something so that Mr. Pfeiffer could get another officer here. We do have a serious issue here. I'm going to object to the testimony anyways, pursuant to the Confrontation Clause and the law created in the United States versus, Crawford versus Washington, because unfortunately the complaining witness is deceased. So I'm going to be objecting to the 911 as well as testimony. So I'm asking for dismissal, Your Honor. Thank you.
Response?
First of all, as to the Confrontation Clause does not apply to preliminary examination per People v. Only, which is a Michigan Supreme Court case from, I believe it was late last year. Secondly, Officer Clark is specifically needed because she is the one who took statements from the victim, which is how the people intend to introduce said statements from the deceased victim under MCL 768.27c. Again, confrontation in Crawford is an argument for trial, not for preliminary examination that has been found to be an evidentiary hearing. Additionally, the people are confident that we can meet our burden per Crawford in it being deemed an ongoing emergency in this matter at trial, but that is neither here nor there because it's not an issue at this stage. Thirdly, there have been 2 delays by the defense. The first was 2 months ago when the defense decided to want to go on vacation. And I will note at that point, at the date of that preliminary examination, the victim was still alive. We would have heard her testimony. But it was adjourned at defense request 2 months. Then we got here, and it was adjourned again because the defense couldn't figure out how to get the evidence open and didn't figure that out in the months that it was already adjourned. People had no objection with that. We're patient in regards to that. Your Honor, I discovered this issue now less than 10 minutes ago. I'm telling you, as an officer of the court, that the people subpoenaed Officer Ariana Clark. In fact, I can pull it up, give you an exact date. People subpoenaed her on 6/17/2022. It was sent to the Lansing Police Department at 120 West Michigan Avenue, Lansing, Michigan. As is the protocol where we send all Lansing Police Department subpoenas. Now, one told me that she had changed professions, we changed departments. I just found that out today. Given the fact that we've had numerous adjournments by the defense already, I'm asking for a single and first time adjournment request on behalf of the prosecution in order for Officer Clark or former Officer Clark, depending on where she is now, to be properly subpoenaed to testify here. I believe it is only fair and appropriate, Your Honor, for such an adjournment.
Well, let's see, I want to make sure the record's clear on the history of the case. On April 19th was the first prelim set for April 28th. That was the probable cause in the prelim. I have that. So that was the date of arraignment. April 19th was the date of arraignment. It was set for April 28th for preliminary examination, and that was adjourned. And I don't have any notes indicating the reason for the adjournment. I do have the May 4th was reset to June 16th per stipend order and 21-day waiver. So the 21-day waiver has been done in this case. And that was on May 4th. And so let me make sure the file reflects, just for my purposes, that we have a 21-day waiver. I have the appearance of counsel on April 18th. And I have a note indicating that there was a waiver.
Your Honor, if
Yes.
you'd like, I can approach with a copy of the signed stipend order.
Here it is, stipend order. I've got it. Thank you. So that was done, received on May. So that was received on May 4th. Then there was a June 16th adjournment for discovery purposes. And now we're July 5th. But I do see now that we're at least 2 months after the adjournment of the 21-day waiver, which indicates that this case is accruing days, but it also indicates that this case, that both parties have made amends to adjourn in this case, as I see it, especially since it's been ongoing. So I don't know that another adjournment is going to establish the case. I will say this for the record. My options are dismiss without prejudice or adjourn it. And if I dismiss without prejudice, I'm certain counsel is going to reissue on some level. And so we're right back here again on some level. I mean, we're right back. There's a rearrangement, there's a rearrest, those things of nature. I'm just assuming that for preliminary examination purposes, there'll be a reissue based on confrontation not being a part of the statute for preliminary examination purposes. The court has recognized the case before. I don't know if the court agrees with the case, but the court's recognized the case. So I'm going to grant the adjournment and get a new date for our purposes. That would be, this is the last adjournment to provide. I don't think we can adjourn it anymore.
That is understood. Your
Yeah,
Honor.
we're well into May, June. We're approaching 90 days on a case. Mr. Anderson is out of jail, so he's not incarcerated. But I understand that counsel and Mr. Anderson, at least counsel's coming from Detroit, and we don't want to make that routine. But we do have a signed stipend order. Let's see, let's get a date for the adjournment.
Next week.
We can do it as early as next week, but we want to make sure and do it in a fashion that where I will defer to defense counsel for your calendar on some level.
Judge, I appreciate everything you said. I am not really appreciative of Mr. Pfeiffer's comments, even though we seem to have gotten along. Whether counsel has a vacation planned and prepaid is really offensive to hear. And my fact of preserving things for the record is very important, whether we have Crawford or hearsay. I certainly understand the law.
Sure.
But nonetheless, I appreciate what the court is doing, and I can look at my calendar here and
So would you prefer we give you a date and you check?
Sure.
So
July 12th.
how does July 12th?
At 1:30?
Yeah, we'll do
No,
July
you
12th at
said-
1:30.
Is the 13th available just because there's that day?
It's a landlord tenant day.
Okay,
So
so,
we could also do it on we could do it on a Thursday or a Friday, since I don't think whatever the nature of any testimony will be a large amount. So we actually have Thursday, Friday, or Tuesday afternoon are the best days for preliminary examination times.
Thursday and Friday, I have exams on both days, or exam and evidence hearing. So let's go ahead with the 12th, Your Honor. And can we say 2 o'clock just to assure
Sure.
that there's not a problem?
Will that work with your schedule, Mr. Pfeiffer?
If
Or
it
you'll
doesn't,
make it
Your
work?
Honor- Yeah, if it doesn't, Your Honor, I will have somebody else from my unit cover it.
All right.
I will make it work.
All right. So July 12th, 2022 at 2 o'clock for preliminary examination. Exam. And we'll make it at 2 to make sure everybody has time to get here, because I understand people are traveling. Is there anything else for the record for docket 22-00846, Mr. Pfeiffer?
Not from the people, Your Honor.
All right, Ms. Stout, I'm gonna make inquiry of your client. This is being adjourned, okay? That's not news to you. So keep in contact with Ms. Stout regarding this file, because we plan on having a prelim on July 12th at 2 o'clock, okay? Anything, Ms. Stout?
No, thank you, Judge.
All right, thank you, ma'am. Thank you for your appearance today, sir. We'll see everybody a week from today, okay?